Hi everyone. Oh, hello. No. Uh, we do. Yes, we have one too many. So I can sit. Yeah, I can sit here, and then you can sit there, and then No, it's gonna. It's you and me. Hello. Not yet. Oh, okay. Because we need headphones. I need headphones.
You got your badge?
Yes, yeah, and I do. Hello. Okay. Yep, we're good. So we'll start in a minute, I guess, just when Khadija comes back to the podium. I feel a very long way from the audience. Does the audience feel a long way from the panel? By the looks of it, yes. So we should start. So welcome to this panel. It's Thursday afternoon. I know that the environment is a little trying with these headphones. I moderated a panel yesterday and everyone had headphones on like this, and I'm Australian, but I live in New York, and generally when people have headphones on, it means they're listening to rap music. I know that you're not, but it's also still a little disconcerting because it feels like I'm on the subway, where if you've been there, you'll see that everyone's sitting there bobbing their heads. Uh, I feel incredibly honoured actually to be here with this panel because there's such a extraordinary range of expertise. I wish there was more of you in the audience. But let me actually, what I might just do is just, rather than me introducing each of the panelists, if each of the panelists, starting with Patrick, if you could just literally just 2 seconds, just introduce yourself and, you know, one line or so just to say who you are, that would be great.
So my name is Patrik Hiselius. I represent Telia Sonera, which is an operator in the Nordic and Baltics and the Eurasian region.
That's fine.
Yeah.
Just to identify yourself.
A very quick identification from my side too. My name is Antoaneta Angelova Krasteva and I work for the European Commission. I'm heading the unit dealing and responsible for stakeholders.
My name is Brett Solomon. I'm the Executive Director of accessnow.org.
My name is Johan Hallenborg. I work at the Ministry of Foreign Affairs in Stockholm at the Human Rights Department.
And I'm David Sullivan, Policy Director at the Global Network Initiative, which is a coalition of technology companies, human rights groups, and other stakeholders working on freedom of expression and privacy rights.
I'm Vivek Krishnamurthy. I'm a lawyer with the Corporate Social Responsibility practice at Foley Hoag, which is a law firm in Washington, D.C.
Good afternoon. I'm Veridiana Limonti. It's very weird listening to yourself. I'm a lawyer at a Brazilian consumer organization, and I'm also one of the third sector representatives at the Brazilian Internet Steering Committee.
Hi, my name is Khadija Ismailova. I'm journalist in Azerbaijan, and this year I authored the Freedom House Freedom on the Net report about Azerbaijan, which included lots of issues on this topic.
Okay, so let's kick off. Is it just my? It's just me, I think. Yeah, I might actually just talk like that. I had crackling in my ear. So essentially, this panel is looking at the role of telecoms, which I think have increasingly become a gateway to human rights. You know, what extraordinary access telecoms have all around the world. And as a result, what access people, citizens have to communications to be able to connect with each other across borders, across issues, across everything. Essentially, we have this amazing exponential growth of communication, and I think we have the telecom sector in a way to thank for that. And what a shot in the arm it has provided to freedom of expression and to association and many of the other rights that we enjoy in the non-digital environment. For this kind of reason, I've been thinking about, you know, telecom providers as freedom providers, but you know, at the same time, as we know, and we know even in this country here, that telcos have information that if put into the wrong hands can be extremely serious. And actually I was speaking to a fellow earlier on today who was telling me about his uncle who lived during World War II in Amsterdam, and when the Germans arrived and they were looking for the Jewish community in Amsterdam, they went straight to the Office of Births and Deaths and Marriages, and that's where they got all of that data from. And once they had that data, they had the addresses, they simply went and rounded up the individuals. Now if we transpose that into an environment in 2012, as we know, it's not just paper records. We have everything, records of conversations, address books, even geolocation of the individuals in real time. And this provides us with an extraordinarily frightening, potentially frightening set of circumstances. So these are kind of the two poles, and I think we're grappling with that environment as we speak. What I'd like to do in this panel is to deal with some of those issues, and I think we'd like to deal with those issues directly. We'd like to have an honest conversation, because I don't think the companies, the governments, the European Commission, the user rights groups, the activists want to be in a situation whereby individual users' rights are at risk, rather where the rights of freedom of association and expression, etc., is enjoyed by as many as possible. So let me start with Vivek. Vivek, how important do you think telecoms have become to freedom of expression rights internationally?
Well, first of all, I'd like to say I'm very happy to be here on this panel with these very distinguished people. I think telecommunications companies have become extremely important in terms of providing individuals with the practical means by which to express themselves. Most freedom of expression as a practical matter happens via the circuits of telecommunications companies. It's no longer the case that the freedom of expression is really exercised by the lone individual on the soapbox, which is the classic idea that we have in most legal systems of the freedom of expression. It's really the idea of public speech comes from that, you know, the public square, but the public square is now increasingly a digital square. So telecom companies both provide the last mile access to the internet in most countries, and frankly, the traditional fixed line telecommunication idea of being able to call person to person is very important to not just the freedom of expression, but to the freedom of association. It's one of the key ways in which we associate with our friends, our family, for both personal purposes and for political purposes. So telcos are really at the center of some of those core political and civil rights.
And Virginia, from your perspective, yes, you need your headphones on to. Can you give us a sense from the kind of the user perspective, how significant the telecom sector has become to both the provision and potentially also to the denial of rights?
Well, it's really important, as you said, telecom providers can be understood as freedom providers and as a way to get to this digital square. But at the same time, telecom providers are deal with internet and deal with the service that they provide as business. So we have to combine these two perspectives. This is the big challenge that we are facing here, because the fact that they deal with that as business brings to us a lot of issues like net neutrality or the violation of net neutrality, a very serious way to deal with personal data and other things that we can raise here. But this is, well, two issues that I put in the table now. So I think that having a multi-stakeholder approach about it, it's important to try to understand what we can, the things that we can deal between us. You know, something that we discuss a lot in Brazil. And IDEC, which is my organization, Brazilian Institute for Consumer Defense, we discuss a lot the importance of social participation in regulation. So as the regulatory agency, as a space, so the regulatory agency being a space where companies and consumers can meet in a equilibrate way. So that's how I see it.
So I feel as if we're experiencing multi-stakeholderism on this panel, and I said to the panelists beforehand, it's fine if no audience turn up because we can actually have our own multi-stakeholder dialogue between us. And in fact, we have got an email list developed, and we're going to add our final panelists, and we will continue to have this conversation. And let's pick up on this issue of the multi-stakeholder environment, because telcos traditionally have not been comfortable or sensitized, I think, to a multi-stakeholder environment, for want of a better word, again, to help with the development of policy or with indeed the operationalizing of those policies. And so David is here from the Global Network Initiative, GNI, which is in a sense one of the poster child of multi-stakeholderism, I think, because it has attempted to bring together internet companies or ICT companies and civil society and government. Let's hear a little bit about that and how you think the multi-stakeholder environment might be appropriate to telcos.
Sure, thanks a lot, Brett. It's really exciting to be here, and I'm really looking forward to this conversation. So I think it is an interesting thing and worth noting here at the IGF, and in the context of the sort of rich multi-stakeholder history and tradition of internet governance, that different companies come from different traditions. The Global Network Initiative, where I work and which hopefully you've heard about in other panels from our members, be it technology companies like Google, Microsoft, and Yahoo, or human rights organizations, press freedom organizations, and academic researchers, brings those groups together to define standards for how companies can responsibly respond to when governments make requests of them that impact rights to freedom of expression or privacy. Now, that our initiative was formed out of a lot of the challenges that internet companies in particular were facing in China. One thing that's worth noting now is that I think the kind of scrutiny that companies like Google and Microsoft and Yahoo were facing, you know, back during the mid-2000s is starting to, I think, be applied on some of on the telecoms industry in particular, but which comes out of a history that is very different from, if we can stereotype for a moment, the sort of internet companies in, you know, Silicon Valley, coming from this kind of libertarian internet tradition, and then telecommunications companies, many of which are former monopolies, you know, may still be state-owned to various extents, and who've been working with governments and government requests for either law enforcement or national security reasons for a very long time. And so they're needing to make this shift to figure out how can we handle these fast-moving issues that are either as a result of, you know, technological advances or from political, you know, dramatic political advances. If we think about, you know, some of the countries where the most attention is going on right now, where you have the most horrific human rights abuses happening, a place like Syria, you know, it was only a few years ago that sort of the kind of deterioration that we've seen in Syria would be was not foreseeable. And yet companies like telecommunications companies in particular are making massive investments over the long term and need to be ready for these kinds of fast-moving changes, and working with other stakeholders is a way to do that.
Patrick from Telesonora, it's probably a good time to bring you in, both in terms of David's point around the multi-stakeholder environment, but also he talks about these fast-moving issues. How are you coping with these fast-moving issues?
Thank you, Brett. Well, I've been working since many years with copyright issues, piracy issues, blocking of child sexual abuse images, and now lately also with human rights, freedom of expression and privacy issues. And these are complex and very evolving issues. We talked about just before the session here that the IGF as a multi-stakeholder forum has evolved. Only some few years ago, human rights were not on the top of the agenda, but today they are. Many or even most sessions are about these issues, which is good. So they are complex and very evolving issues, and they are important because for us as a telecom operator, we have a duty to implement the Ruggie framework, which mandates us to respect human rights, and we need to work to define how to do that. And last but not least, they are important because these issues are about individuals, about persons, about friends and neighbors and our children. And the multi-stakeholder aspect is important indeed, and that's why I'm here at the IGF and in other for us to discuss the issues with other stakeholders.
Can I just say that we did invite a number of other telecoms to be present on the panel, and special props to Patrick and Telesonora for actually being here. We very much appreciate it. I think this is great. This is awesome. We're sitting here in a multi-stakeholder panel. We've got, you know, a fantastic audience. We're within the IGF. But when we think about Telesonora, it's a European company, and I'm going to ask Antoinetta a question in a moment about the European Commission and the context in which she is operating, and the controls perhaps and the regulations and the oversight and the introductions of voluntary standards within the European context. But Patrick, what's your views on some of the non-European and non-American operators? You know, I can name some companies, I don't necessarily need to, but there are companies out there that aren't even having these conversations, that wouldn't be sitting at a panel like this. In fact, probably don't necessarily even have a unit within the company that's thinking within a human rights framework. What do you think about that, and in particular in relation to your operations in countries where there are human rights abuses taking place?
Well, some short thoughts on that. First, of course, as already mentioned, every company, not only telcos, but every company has a duty following Ruggie to respect human rights and need to find out to do that and to improve their work. I would think also, at least from our company's point of view, human rights and respecting human rights is a means of competition, because we need the trust of our customers. And when it comes to freedom of expression, well, our business is communications, so we want our customers to be able to communicate, not networks to be blocked or shut down.
So you say every company has a duty to protect the human rights.
To respect.
Okay, and respect. And if we think about the Ruggie framework, and I don't know if anybody else wants to come in on this, or somebody from the audience perhaps, I understand the Ruggie framework to be about respect, protect, and to remedy as well. And I understand that the company is also has a duty under the Ruggie framework for that third element, which is if a person's rights are actually abused or impacted negatively as a result of a company, then the company has a responsibility to provide some sort of remedy. Do you subscribe to that position?
I do, and we all stakeholders need to work with the remedy part, including business.
The reason why I raise it is because my organisation, Access, is looking at these issues regularly, and the remedy component always seems to drop off the agenda. And I think it's important in public forums like this that we look at the whole framework, which has three elements to it. The first element, of course, is relates to the state. Speaking of the state, Antoinetta, could you give us a sense within the European Commission environment of building off the point that Patrick made about the duty that they have? How do you actually oversee, frame that duty, and what kind of initiatives are happening within the Commission that might be relevant to the work of Patrick and Telesonora, and indeed many of the other European companies? It's important to note that when we talk about emerging markets, the emerging markets and the operators that are there generally follow a line of colonialization, in the sense that you see that there are, you know, European companies like Telesonora, which are through Central Asia, others that are through Northern Africa and through Southern Africa, etc. So the European telco is actually extremely important here, and which places you and the Commission in a very fortunate position, in the sense that I think there's an opportunity for great influence.
Thank you, Patrick. I hope I can hear. Yeah, sorry, Brett. I hope I can hear myself, but this is not the case. So I'll keep my headphones on. Yeah, indeed, there are several issues involved in this. First, starting with the commitment of the European Union in general to promote human rights. And on the other hand, also to help the EU industry to remain competitive, because you already mentioned non-European countries, non-European enterprises which may not respect the Ruggie framework or implement it properly. So this is indeed a great challenge, but we see this challenge also addressing it by creating opportunities, and by applying multi-stakeholder approach, we are trying to address these issues. What we are doing is implementing a framework for corporate social responsibility under the corporate social responsibility communication adopted in November 2011, where human rights are given particular prominence. And we have a very concrete action there, which aims to put in place a concrete guide for not only the telecom and not only for the telcos, but for the whole range of enterprises involved in the ICT sector, and to bring together, to bring into this discussion the various actors active in this area, to talk to civil society, but also consumers, users. What we are doing currently is actually, together with contractors, the Institute for Human Rights and Business, and CHIEF, is to develop such a guide. As probably many of you know, in the ICT sector in Europe, there are a lot of SMEs who are involved, so we will also trying to develop a guide for them, because the issues should be tackled in an appropriate way and also responding to their particular needs. We are also looking at the various initiatives because there are various initiatives at European level. The US is doing a lot. Initiatives which are taken by the industry itself or by civil society organizations. So what we are trying to avoid is fragmentation, because this is something which will not be constructive for this dialogue. We are also looking at practical ways of tackling these issues and finding practical solutions to them. It is indeed important to have a real networking, not mere coexistence of the initiatives. I'll stop here because I already put several issues on the table, and I'll be happy to further discuss them with the other panelists.
So, some great developments of policy within the European context. I think a company that's learning, that has been burnt by situations, like many other companies. We can think about Nokia Siemens networks, for instance, or Vodafone. So Nokia Siemens networks in the context of Iran, Vodafone in the context of Egypt. Let's hear from Khadija about her experience as a person within Azerbaijan, and some of the environment here that you and your colleagues are facing in terms of issues around surveillance potentially, or censorship of content. Khadija, the floor is yours.
Thank you. And I want to start with first of all the regulation in the country that basically makes it very difficult for companies to respect human rights in the country, which is the law on investigation and search activities. It's clause number 10. Allows law enforcement agencies to conduct surveillance without court order in investigations of grave crimes against person and for prevention of the grave crimes against state. Amended special rules for additional technical support to the investigative intelligence efforts by communication enterprises and communication networks foresee that communication companies, telecom companies, are obliged to provide all necessary technical means as required by the Ministry of National Security, including special rooms, communication channels, etc. The Ministry of National Security bears responsibility for correspondence of the surveillance activity to Azerbaijani legislations. Interviewed respondents, I interviewed several people who confirmed that the law enforcement agencies referred to the surveillance data during interrogation of opposition activists within investigation of March 11 rallies, for example, of 2011. And this data taken without court order, and actually as law refers to the grave crimes and prevention of the grave crimes against state. In these cases, none of these crimes could be considered grave crimes or crimes against state. Yeah. These journalists or opposition activists during interrogation were like the law enforcement agencies put before them the printouts of their email communication, the conversation of their phone conversation transcripts, without court order, without nothing. The latest case is the case of Nigar Yagublu. She's the daughter of opposition activist. She was involved in car accident, but right after the car accident, her phone was tapped, and the deputy prosecutors, deputy general prosecutor, referred to their phone conversation in his public interview. He said, we listened to her phone conversation. It's just a car accident. It's not a crime against state. It's car accident, just a car accident. And this is one of the late examples. And another example is the Another example is in 2007, journalist Agil Khalil was stabbed by, and the pictures where he identified people who stabbed him were pointing to Ministry of National Security officials, but the government wanted to present him a gay in homophobic country, and they found some gay who said he stabbed the guy because he was his lover, and they presented the transcript of SMSs as if sent by this gay and to this journalist, and the journalist said he didn't know that guy at all, and that company Azercell provided or didn't provide Ministry of National Security or Prosecutor's Office, just made up those SMSs. But the company didn't cooperate with Agil Khalil's lawyer, so they couldn't get the information from the company themselves. Azercell, by the way, the Telecoms partner here in Azerbaijan.
So, can I ask you a question just to take you back? You said the regulatory environment, so the operating license that a company is required to sign if it wants to enter the country, makes it very difficult to adhere to human rights within the country. How does that get changed? How do you alter that environment?
Yes.
Because I think many companies are looking at emerging markets. For instance, Telesonora right now is looking at an interest in Burma, and many other companies are in a similar situation, and the operating license is very rarely disclosed. i.e. we don't know what the operating license says, and we don't know what the company has agreed to in order to enter into the market. In the absence of having a sector-wide position, you end up in an environment where companies are doing a race to the bottom, offering more and more and more rather than having sector-wide standards which said, actually, if you want access to data, you require a judicial order. So how do we shift this environment within the Azerbaijani context or more broadly?
Again, these rules, the legislation says that Ministry of National Security should do it only during investigation of grave state crimes, to prevent state crimes or investigation of grave crimes. And it's rules established by the Ministry of Communication. This is not the law, so it can be questioned. And the telecom companies can question the intention of Ministry of National Security to do this surveillance if they have guts to do so. Well, that's a problem. They don't have guts in some cases, like Telesonera partner. In other cases, they don't have desire to do so when the telecom company is actually the president's daughter's company, which is the case in Azerbaijan. In 2011, we discovered that the company that operates in the country since 2006, and the government was telling us that the Siemens is the owner, is actually belongs to president's daughters through offshore companies in Panama. And that company owns another company, Azer Telecom, which is second backbone internet provider in the country. So they have lots of control over email, telephone, and everything. So in these cases, we cannot even expect them to desire to question those activities by Ministry of National Security. I don't know if Azercell would desire, did desire, if they tried to question. I don't know that, but I know that they could cooperate with lawyers of journalists, lawyers of the activists, but they never did so.
Thanks very much, Khadija. And I'd also just like to acknowledge Khadija's role on this panel as well, which is and her bravery in being so public in her position. And I'd just like to take a second to thank you very much for being on the panel and to get a response from Telesonora, which is a minority owner of Azercell, as I understand, and just to respond to some of the comments that you've heard would be good.
Just one small comment. One of the things we also want to know is who are the partners of Telesonera in Azercell ownership. I mean, really who are the partners. That would be also very useful information, because we don't, the Ministry of Communication basically returns the information requests, says they don't know, and the they say that I sent information requests, they sent me information requests, that they are not carriers of this information. So we want to know who knows, and can we get that information.
Thank you. As to the ownership issue, Telia Sonera Group owns 75% of an investment company, which is Finter Holdings, and that company in turn owns 51% of Azercell. So effective ownership is 36% something, but we act in practical terms as a majority owner of Azercell. As to other questions regarding ownership, maybe I can help you after the seminar to find someone who can answer your questions. In my regard, always when it comes to surveillance and measures, rule of law should of course apply, and an innocent person should not be intimidated, and measures, if any, should follow by rule of law. Felony describing law and measures defined and possibility to appeal and all that. To be very straightforward, I think what Katica is talking about is this what has been mentioned in media as black boxes, where all information is intercepted. And let me say that access to frequencies is owned by the government. It's owned by a state and therefore by government. So national law, including license requirement, is a matter of most often so of national security. And this means that our network can be monitored even without us being aware of it, exactly like Katica has explained here. Regarding these licenses, there is very little individual company can do. The same license requirements apply to all operators in a country. And the state, any state, anywhere in the world, in its legislation, which includes license requirements, which are part of regulation in large, decides the balance between national security issues and human rights. And the state can also imply other requirements, such as coverage requirements when there is deployment of networks, or transparency, or consumer protection, or anything else. What we can do as an industry is to lobby this kind of regulation. Also license requirements. But when the regulation is there, we need to follow it. So that comes back then to the Ruggie framework. What can we do more than follow regulation? And then we talk about processes to improve our processes when handling surveillance requests, ensure that these processes are followed, educate our employees, work with transparency. I inform the public afterwards if possible, because many times this is under confidentiality. And of course, as has already been mentioned here, work within industry, because other operators are in the very same situation in the country as such and in other countries. Well, in summary then, so these frequencies are owned by the governments, and it's not strange that the government decides what prerequisites that apply when handing over such licenses.
It's certainly true that in many cases the government has access to those frequencies, but the allegations of Telia Sonera have been more active than that, in the sense that the black box that you're talking about, I think, has been I think in Belarus has been actually that the government has been itself has been located in the same offices as TeliaSonera and has had hands-on access, has sort of, had their hands in the data box in the context of TeliaSonera's own operations. Is that, this point being is that it's not just the government that is taking access, gaining access to the frequency, but TeliaSonera has actually played a more active role than that.
I would disagree that TeliaSonera has played an active role. What happens? First, I need to say that TeliaSonera does not have operations in Belarus. We don't have any majority control of the operations there. We have a minority post through through Turkcell. But in general terms, I, as most other people, understand the emotional perspective of a connection to our network being placed in the same building or very close to the head offices of a company. So there is an emotional side to this and challenge. Whereas from a technical point of view, I'm not an engineer, but I know that to intercept traffic, it does not matter if it's done here or several kilometers from there. It's hooking on to the network. But I agree that there's an emotional challenge in such a situation. But we do not take active part. We work with our procedures, but as a telecom companies, we do not participate in the decisions on proportionality between national security and human rights. That's something which is done by legislator and authorities.
Which does raise the question about compliance with international law or compliance with local law, and perhaps Johan, you'd like to address that issue. Many operators are working within an environment where the national laws are not necessarily consistent with international standards. And how should a company balance that?
Well, I think maybe that question needs to be put not just to the government, but also to companies. But from our perspective, this work with freedom of information, freedom of communication, freedom of the internet has several legs. It has a sort of a policy making part, which we work with through United Nations, through the EU, Council of Europe, and others. It has a dimension of providing practical help and assistance to people who are at danger, at risk. And we do that mainly through our development cooperation arm, through SIDA, where quite a lot of funding is going directly to people at risk in repressive regimes, in repressive situations, where they need help to improve their way of communication. The third part that we actively work with is the company side, the corporate responsibility. And this is something that is very close sort of to our minister's interest and minister's heart. There has been a lot of development going on in this field over the past few years. We've actively engaged in the GNI, trying to promote that as we can. Our minister has took the initiative of a roundtable discussion in Stockholm with about 50 of the main telcos and other stakeholders in addressing these issues. So that is the broader picture. The Swedish government owns part of TeliaSonera, about 38%. And as owners, we have expectations on Telia. That is quite clear. And this is something that the government has been very clear about. Our expectations would have to go hand in hand with our commitment under the Ruggie framework. The Ruggie framework, as Patrick said, is now to be implemented. And that is an implementation that is done not just at corporate level, but also at national government level. My government and all other governments who have agreed to this framework now has to develop national plans how the government intends to work actively with the Ruggie framework. And in my administration, this work has just begun. And I understand that it's the same in Patrick's company, but I know that they have been working on these issues for several years. And the government do have expectations on the companies that we are involved in, that they adhere to these basic principles. Now, we fully understand that there may be situations where companies are faced with very, very difficult decisions in local contexts, where local law clearly contravenes international human rights law. And I think it's falling back on commitments on the Ruggie framework. We would be very happy to help and assist, if we can, companies to follow that framework. It is, of course, difficult to give a clear-cut answer, but I wouldn't sort of encourage companies to actively break national laws in countries that they work in. But at the same time, we need to work closely on figuring out how the Ruggie framework can be adjusted and can be implemented in very difficult situations. I think it's important what Patrick said about process. We need to assist in situations where there is a deficiency in terms of rule of law. Can we, as other governments, help and assist in any way? The same goes for transparency. I don't think there is necessarily, we've seen how certain companies in the IT sector, for example Google, they're very transparent about the request they get for taking down content. I don't think that there is a sort of a decisive part here that the government has to do all of this, but telcos may also find that there is a possibility for them to increase their transparency on these issues, given the context that they're in, of course, and the ability to work. But as owners in Telia, we have a close dialogue with Telia and other companies that we own, and we do have expectations on them. But let me also be quite clear that we support the work that Telia is doing, basically. We support increased access to information, increased access to the internet, also in repressive regimes. And this is important to remember. We would never have been able to get as much information about what's going on in Iran, in Syria, without the existence of mobile networks.
So we've heard from everyone on the panel now. I think we know where most people... Of course.
Well, there is something Swedish government can do, there is something Swedish companies can do, and all other companies can do. First of all, some cases are going now European Court of Human Rights, where Azercell's activity and TeliaSonera's activity is mentioned, particularly with Agil Khalil's case, when TeliaSonera's partners here in Azerbaijan didn't provide copies of SMSs to the owner of the phone line, so he couldn't use that in the court against the government's claims. But well, that's another story. But what can Swedish government, for example, do? You are the participant of. You have say in ITU. You do have say in Council of Europe. So you can promote this transparency and responsibility and respect to human rights in communication sector, and especially in legislative level within those organizations. And it's very important to raise these issues in those organizations. In non-parliamentary cases, Swedish parliament members are doing a good job in parliamentary assembly, but we would like to hear more from Swedish government in this organization, in Ministerial Council, in ITU, and other organizations where they are represented.
Yeah, I'd just get a quick response from Johan and also from Patrick on that.
No, I fully agree. We need to be very active in those arenas, in those forums. What I wanted to respond was more directly linked to our involvement in the ownership in Telia Sonera. But I think also our involvement in the Council of Europe is important, but I think also more importantly for us is the European Union, where actual law is being made and actually binding legislation is being passed. So that in combination with other work of more of a soft law character is absolutely necessary.
Just to clarify, I mentioned Council of Europe and ITU because Azerbaijan is not member of the European Union, and you can use your influence, your say, your right to say something, raise the issues in those organizations to make Azerbaijani government to be more respectful. So then, you Swedish government and Swedish companies would not have dirt on them, you know.
Thank you, Brett. Thank you, Katis. As to the specific case with the SMSs, I'm sorry, I'm not aware of the case, so I'm unable to.
Just while we're here, it might be a good idea if you could, in fact, look into a case of Agil and have a look and see what the prevention was from the handing over of those SMS, because I think that would be useful, if possible.
Yeah, so maybe we can talk after the panel. And the other question I understand is what we can do as to these processes. And as said, we are improving all the time, and we are, I think, in a benchmark, very good at being transparent at what we do. So you can find, all of you can find very much information on the teliasonera.com homepage on what measures we have taken in the last 8 or 9 months regarding these issues. And then of course, as we have spoken about here, we are defining also together with other telecom companies how to improve processes when it comes to government demands. And that's all about that government's requests are reviewed by qualified personnel, and that we establish guidance to that personnel when that receive such requests, and that we develop strategies that might include such as reviewing the demand with the authority that has submitted it, maybe seeking judicial review, i.e. court procedure in other parts of the government, appealing, engaging with the UN or other EU or other supranational organizations, and again engaging with stakeholders. And as to multi-stakeholder dialogue, I think Telia Sonera and the full industry has more work to do.
So at some point we should probably define the Ruggie framework. I also just want to pick up on the point of transparency as well, and to thank Johan for coming out, so to speak, that the Swedish government is a 37% holder, 31% holder of Telia Sonera, which means that it's not just the host country, it's also an owner of the company that's operating within Azerbaijan. I'm so conflicted at the moment because every panelist here I know wants to say something, but I think it'd be great if we go out to the audience, get some comments, and then we'll come back to the panel. So have some comments, questions, concerns from anybody out there. Yep. We'll start here and then there. Can I get a microphone to the front? Thank you. If you could just identify yourself as well briefly. And if you could keep your comments relatively brief, that would be great.
Yes, thank you. My name is Elvana Thaci, and I work for the Council of Europe. Thank you to all the panelists for the very rich contributions. I have a question for the representative of Telia Sonera. You mentioned the implementation of the Ruggie framework. Could you elaborate further? What types of tools are you making available to users? because users are also an important actor in the interactions that might be taking place to implement that framework. So, practically speaking, what tools, what processes are you making available to users? The reason why I'm mentioning this is because in the Council of Europe, we are also working on a compendium of rights of internet users, which should enable users to understand better what their rights are online and to seek effective remedies when they think that their rights are abused.
Great.
So please, that's
Thank
my
you.
question. Thank you.
Vadiana, can I get you to respond to that first?
Well, I can tell about the importance of these tools and processes, but the real question is, I don't know what Telesonora is thinking about it. But when Brad called me to this panel, one of the questions that he raised was about what consumers or users should know about what kind of information the users should have about the services to be engaged in their rights defense. And I think that the things that you bring to us, it's very important to respond, to answer the question that Braid made to me. Because it's not only important to the consumers knowing their rights, generic, so the human rights that are involved in the provision of the service. It's also important to consumers and users to know what practices are done by the companies regarding these rights. So about freedom of expression, about privacy policy, about some kind of blocking or filtering in the traffic. And especially, it's very important to know how to redress and how to complain, not only if what they say is not being accomplished, but if what they say is not what human rights or the legislation say that has to be done. It has to be done. So it's very important to know not only what the companies are doing to lead better with to deal better with this, but also what national and international regulations are doing to improve these processes. So this is very important for us in our day-to-day activity.
Thank you. Can you pass the microphone back if it's okay, because there's other people who want to ask questions, so it's just there's a person behind you.
No, I just wanted to mention that my question was addressed to
I'm actually going to get him to respond in a second when it's his yeah. I'm going to bring him back in. It's fine. We'll get a response. Do you mind passing the microphone back? Thank you.
Hello, my name is Elena, and I'm from... Oh, is this better?
Yeah.
Better?
Yeah.
Okay. Hello, my name is Elena, and I'm from the Center for Internet and Society based in Bangalore. And I want to thank you for bringing up the concept of transparency. And I was just wondering if you could actually, one of the panelists could pull that idea apart a little bit and talk about what practically can telcos be transparent about, and what would actually catalyze change? Like, what kind of transparency would catalyze change?
Thank you. I might pass that conversation to David from G&I, and perhaps Vivek if you've got a comment as well.
Yeah, I think that transparency is a key piece of the equation, and certainly you know, you can look to the Google transparency reports. Other internet companies like Twitter are also starting to do transparency reports. But I think there's a couple other dimensions of it that are quite key. One is that in the United States, actually, and this is one of the, I think, the issues that makes this a difficult topic, is that although the gravest human rights risks most oftentimes occur in authoritarian regimes and non-democracies, but this difficult relationship between companies and national security and law enforcement agencies of government happens in every country around the world. And so trying to make sure we apply international human rights standards that sort of take an objective approach is quite crucial. But so in the US actually recently, a congressman wrote to the major telecommunications providers there to ask for information about the number of law enforcement requests they received, and they responded to him with public letters, and the amount of information that disclosed varied, from company to company. But I think it demonstrated the possibility, of these kinds of companies making disclosures about what they are receiving. Now, obviously, different companies have very different amounts of types of requests, amounts of requests, things like that. If you look at the difference between, go back to the internet example for a second, the Google transparency report compared with the Twitter transparency report, which is a much smaller company, very few, much smaller numbers of requests compared. And I think in the case of, certainly with multinational telecommunications companies, you're going to have much higher volume. But these are things that can be worked around. I think the other thing is government transparency, and this is another opportunity for government, for companies and civil society and other key players to pass legislation, to lobby governments to be transparent about the requests that they're making of companies. One of the key business and human rights initiatives out there that comes from another industry that's come under intense human rights scrutiny is when it comes to oil, gas, and mining. And there you have the Extractive Industry Transparency Initiative, which basically has governments disclose the payments that they're made, that companies make to them, and companies disclose what they're paying, and then you can see where it matches up and where it doesn't. And I think that there's avenue for a great deal of work on this in the future.
Yep. Vivek, do you want to jump in, and then we're going to take some more questions from the audience?
Absolutely. I think Virginia also wants to jump in. Very quickly, I agree with everything David said. There's also one other important dimension of transparency. In the law governing, there's an emerging norm in the law governing indigenous peoples of free, prior, and informed consent when it comes to measures that affect an indigenous population. I think this is a really powerful norm that has a lot of application to the internet and to telecommunications. One of the big problems is that consumers and users of these services have very little idea what they're signing up for when they sign that 36-page contract in 5-point font. So having better disclosure around what a telecom is doing with your data, what they're collecting, under what circumstances that information can be disclosed. I mean, this applies to internet companies too, and one of the great efforts in the GNI has been to improve terms of service, both in terms of their substance, but also in terms of their accessibility, making it clear when what you're signing up for and when you are subject to certain kinds of measures. So one of the things that some of the GNI companies do is when there's search filtering, that's disclosed up front. You see it, you see that your search results are being shaped. So I think that telcos could do a much better job of being transparent with their users about what they're signing up for before the fact.
Yeah, Virginia, if it's okay, I'll come back to you. But it's true, and actually none of the telcos, as far as I'm aware, have any sort of transparency report. In fact, we've been speaking with a number of companies asking them to provide the sort of information that Vivek and David are talking about, which is how many requests are you getting from government in the countries in which you operate? What is the nature of those requests, and how many of them do you comply with? And if you're not complying, why? That kind of information, I think, for Khadija and the community of people that she leads will be very, very useful, because you can see where the Azerbaijani government is requesting. If we come back to Patrick's point, however, they have control of the frequencies. Maybe they don't need to actually request data. Maybe they're just skimming it off the top. And of course, we have to consider those technical aspects. Let's move to some further questions. This lady here, can we get the microphone down the front, please? And then sir at the back. Thank you. If you could also just announce yourself, that would be great.
Hi, everyone.
Hi.
My name is Ulvia, and actually I'm Communication Director of Azercell.
Okay.
So I will
Welcome
be the one who might answer
welcome.
the questions that's been raised. So, referring to the question that Khadija Khanum raised regarding Agil Halil's issue, the thing with his issue was that Azercell, as a telecom company in Azerbaijan, doesn't have a service of providing SMS. So in order those SMSs to be provided by the company, one should have a court decision. And at that time, there wasn't any court decision from the lawyer of Agil Halil for those SMSs to be provided. So, but as a company, we don't have neither the service or the obligations in accordance with law and our contract to provide those SMS. So I think that answers the question regarding this.
Can I just ask, and perhaps Khadija could respond, but in the context
No,
of...
that doesn't. The court decision is needed when you are asking the court decision is needed when you are asking someone else's SMSs. But when you are asking your own SMS history, that you cannot ask. It's his own SMS history.
No, as Azercell, we don't have at all the providing SMS transcripts in general. So if even the owner of the number wants to have this SMS, they have to have a court decision, because in general, as a company, we don't have this service.
Can we just get Khadija, if we could
just one thing. This is where inequality comes, because in the countries like Azerbaijan, you don't have courts cooperating with opposition activists, journalists, and so on. So the court decision is required when the company doesn't want to give it to you. So then court decides that it has to give this information. Then, but if company wants to cooperate, it just and the SMS providing company is your partner. You selected that company. Azercell selected that company to work with them, and if that company doesn't respect human rights, it doesn't cooperate with it provides to Ministry of National Security information without court order, and it does not provide that to the victim of the actually tapping. So the journalist, it means there is some
excuse me,
inequality in this issue.
Sorry. What would be great is if this conversation is extremely important, obviously, but it would also be good if this conversation could continue after the panel. I also want to not just focus in on this one particular case, but it does illustrate a principle that I think Virgiana has raised, which is about the user and his or her control and knowledge and permission of use of their data. And it does seem like a basic standard whereby a user should be able to request information about their own data.
That's absolutely true. Maybe we can take the question after the panel, not to involve all of you. I would be happy to answer the questions. But as a last comment, I would also want to underline what Patrick said before, that the frequencies in this country have been owned by the government, and we just lease them. So we just own the infrastructure. And the lease for those contracts are like for 20, 25 years, we lease the frequencies from the country, and then and the government has the right to interfere in accordance with the different legislations. So whenever those defined cases are, they can take the information even without the notification to the company in accordance with the legislations. So wherever Telesanera operates in the local market, they do operate in the accordance with the legislation. We can't break the law. Otherwise, it will be also the violation of the right in this country. And after I can take the question.
So you do have the room in Azercell facility where...
No.
You do have the room in
no,
Azercell
as I
facility
said,
where Ministry of National Security
no,
has
we don't. As I said, because the frequencies have been owned by the government, we don't even have to have this room or whatsoever. So because it is the property of the government.
Okay, so thank you very much for your comments. Very appreciative, and I'm hoping and expecting perhaps from that last intervention that there actually is somebody from the Ministry of Communications from the Azeri government in the audience. Are they going to pop up? No. Okay. So we have raised this question and about the role of Azercell as well, and we talked earlier about companies operating which are not European companies who are now thinking about joining the GNI, potentially a part of an industry dialogue. Is there any multi-stakeholder environment like the GNI that the company could actually, might be interested in joining in order to deal with this on a company-to-company level, to create some kind of standards so that you're not engaging with the government on an unequal footing? Microphone. Yeah.
I think this question is more related to our shareholder, because we are just a local company, but we've been operated by a global holding, TeliaSonera. So maybe Patrick can pick up on this better.
That would be great, Patrick, if you could, and David, it would be good if you two could have a chat after the panel as well. See if you can work your charm.
Thanks, Brett. Sure, as a local company, there is little we can do, although there are things that we can do to respect human rights, things that I have been talking about, and I will answer your question regarding transparency. But what we can do, most importantly, is to come together as an industry. As you mentioned, Brett, the US internet companies have come together in David's organization, the Global Network Initiative, and in a parallel initiative, there are 11 telecom companies who have gathered together and drafted principles for the telecoms industry, so that there is a common set of principles which the companies, including their local branches, can refer to and adhere to. Should I go into the question on transparency?
Actually, it wasn't a question on transparency. It was a question on user tools, right?
Ah, sorry. So
yes, please do, because we've actually only got another 15 or 20 minutes, so we might need to.
Yeah. First, a very short comment on the comment from the lawyer here. There is actually a big difference. There is much more far-going data protection, privacy legislation in the EU compared with the US, so that the European telecom operators, such as TeliaSonera, at least within EU, have a much stronger regulation to adhere to than do the US internet companies. So that partly answers your question. As to user tools, first let me mention that TeliaSonera has a well-elaborated code of conduct and ethics, and we have translated that document to all of our local languages, and that is of course available on our homepage, also for our subscribers, our users and potential subscribers. We have been working, as I said, very much to improve transparency the latest 7 or 8 months, and there is substantive information on our measures and our thinking on our homepage under the heading of sustainability. We published, as part of those initiatives, only a couple of weeks ago, a document which I have printed some copies of here. It's a 6 or 7 page document on freedom of expression and privacy and the international telecoms framework, regulatory framework, where we explain the prerequisites that we adhere to and that we under which we also work to respect the human rights. Maybe I should stop there. There are many other panelists, but I would be happy to come back.
Sir, question from you at the back, if we can pass the microphone. And if you could keep your comments relatively brief, that would be very much appreciated.
Can you hear now?
Yeah.
Okay, good one. So my name is Tero Mustalam, and I'm from Finland, from Nokia Siemens Networks. And I just would like to update the information regarding our activities, because it seems that our company name is referred many times based on the issues which happened in 2007 and so on. And to start with, this Iran case, which is very much referred, we actually after that we made a internal assessment in the company. So what is the case and what we should do to avoid this kind of situations. And there are a couple of things what we did based on that assessment. And the first thing on a principle level was actually that we realized that the old principle that the vendor has no responsibility on how the technology is used is not valid anymore. And we need to do something else. And then we ended up on a decision that we need a company-wide approach to this issue. This is not a simple one. So we need a company-wide issue, and it has to start from the highest management of the company. And the solution, or let's say our approach at the moment to these issues is that the company executive board actually decided or approved, actually as the first in ICT industry, a company human rights policy and the accompanying due diligence process directly related to this matter. And the core of this policy and the process actually is that we need the due diligence process to identify the risk level of the cases where we are bidding in around the globe. And then we need to identify the especially high-risk cases and what to do with those, where we see that some kind of misuse could be possible. So we systematically evaluate the country risk as well as the product risk of each sale. And for that we need both the understanding of the human rights related risks and also a deep understanding on the capabilities of our products.
Yeah.
And in a high-risk cases, we make the analysis and use internal and external experts for that, and then we make decisions whether we are continuing in bidding. And I can tell that we have deferred from bidding because of this principle, which naturally has also financial consequences.
It does, and just to echo.
If I may conclude, I put the phones back then.
Okay.
I'm close to conclusion.
Okay, just one more minute.
So
thank you, sir.
This is basically the core of our current policy: to look at the cases, make the analysis, and then decide whether to continue or not. And so basically, I think as a company we have learned from the past, and we try to, in a way, cope with the modern principles dealing with the human rights issues. And while closing, I would also like to share that like we heard from Telia Sonera just, that also we have joined the wider industry dialogue with many European big operators and a couple of other major vendors, where we try to discuss together how to address these human rights related issues as an industry, to have the kind of responses ready and to be able to cooperate industry-wide and acknowledging the kind of in some cases difficult positions of the operator, because they have to be according the license conditions where they need to adhere, and then also be aware of the human rights issues.
Thank you very much for that. And I have to say that I've read the human rights policy of Nokia Siemens network, and it is actually a very good policy. I have to say, we've reviewed it as a policy team within Access, and it is a major step forward. And it's interesting to note that telecommunication companies generally produce their human rights policy after the crisis, when they're feeling terrible about a situation that's occurred, if we look all the way back to Yahoo, through Nokia Siemens and through to Tele Sonora. And the proactive, preemptive approach of companies who haven't had the crisis is obviously the preferred option. Antoinetta, let's come to you, picking up on this issue about the kind of standards that can be set within the European context, so that Nokia Siemens is not caught in the position where it's providing surveillance equipment, or surveillance equipment which they've sold is being used by a regime. What kind of environment are you providing, or standards can you be setting that can help the companies in these emerging markets? Let's face it, these problems are not going away. In fact, they're probably going to get more significant with time as we get greater numbers of people connected, and more of those emerging markets are in a situation where there may be opposition activists who are using data, or even just mums and dads. It comes back down to a basic privacy issue as well as a security one.
Brett, I fully agree with you that a proactive and preemptive approach is needed. There is already past experience, and we should build any future initiatives and proposals based on this past knowledge. We should see what has worked, what didn't work in our previous experience, in order to learn from this. I think that one of the major issues that were already mentioned was that this, as part of the preemptive actions, telecoms and also all kind of ICT industries involved in different environments should look at the local and national context. They should examine the situation and be prepared for what could be the needs related to the implementation of the existing regulation, what could be the impact of their operations in a certain environment, how they should react. Also, they should look at the supply chain, which are the other actors and agents involved when they are doing business, in order to see what's their track record, or how they should cooperate with them or inform them. It is really very important to be transparent and to be responsible and accountable for their actions. And this is going beyond the legislative obligations, but these are also related to non-legislative kind of responsibility towards the society. Very briefly, I would like only to mention that indicators are needed, and progress should be assessed on a regular basis. And this is what we are trying to do by coming up with guidance for the EU industry and all other actors involved in this, civil society who are involved in this process.
And who do you propose would evaluate the companies against those standards? Is it a state responsibility, or is it an industry responsibility?
We are looking at this in order to come up with the best solution. I mean, I don't want to come up with an immediate answer, because this kind of response should be a response also looking at the industries, the civil society as well. So looking really at the context.
And Khadija, who do you want to be evaluating the companies? Do you want the European Commission? Do you want your national government? Do you want civil society, or do you want a collection of companies themselves?
Well, definitely not my government, because my government is the one who is standing behind these things. And I'm very sorry that Telia, Sonera, and Nokia Siemens Network, or these Western companies investing in these countries, became the primary target in this panel. Is just because you are so transparent, and here you were here, so we were talking about you, but its primary responsibility is on the governments who are doing it, because the government is creating those conditions, and the government is passing and initiating and passing this legislation, and they cannot be part of this evaluation. Definitely, it should be maybe it should be the civil society mechanism, but both with international and local participation, because local NGOs in this country are also subject to bribery, and being bribed by the governments, and becoming the GONGOs, NGO becoming the GONGO, which stands for government organized NGO. So it's we wouldn't want them as well to be part of this evaluation system. Well, it should be as independent as possible.
Okay, I mean this question is actually pivotal because the U.S. Congress, for instance, has the GOFA, Global Online Freedom Act before it, and I think the European Commission is also looking at what kind of enforcement mechanisms can be in place, whether there should be regulation, whether there should be sanctions. And of course, the big question, which we haven't really touched on, is one of when should a company leave? When should a company no longer operate within a jurisdiction? When does providing a service become complicity in human rights abuses? Of course, we're talking at the extreme end of the scale here. Sir, at the back, I think there's a question from you.
Thank you. My name is Ehsan Norouzi. I'm an Iranian journalist living in Berlin. Given what our
Microphone
friends...
closer.
Is it okay now?
Yeah, that's fine. Thank you.
Okay. Given what this gentleman said, about Nokia Siemens and their human rights policies, I cannot consider them as like honest initiatives and efforts because these equipments are still installed and working in Iran. How can you talk about human rights when they're still operating and playing with people's lives? You cannot go there just as a European company and install cascades of centrifuges for Iranian nuclear program and help them access the bomb earlier and then say, okay, we are revising our policies and now we are thinking of human rights. It's not fair. It's not fair and it's not honest at all. And there should be strong punishments for this kind of companies that are helping repressive regimes surveil their citizens. And this process, this is obviously endangering people's lives.
Thank you very much, and thank you for that contribution. We appreciate it. I think we're actually almost at an end, so I might just get a roundup from the panelists. I wish we had some more time to delve deeper into these issues. I feel as though we have actually had an honest conversation about some of the harder issues. We're still in a process, I think, in maturation of the sector to work out how best to deal with them. I think we've seen this industry dialogue developing, which at some point will become a multi-stakeholder environment, let's hope, developing sets of principles, the Global Network Initiative, consumer rights, activists on the ground who are then able to communicate with international networks, the European Commission starting to understand what is involved with the companies that are incorporated within their jurisdiction operating outside, the Swedish government in an interesting position where it's both one of the world's leading advocates for internet freedom, but at the same time is a shareholder in a company that's operating in an insecure environment and the human rights consequences of that. And I think the lawyers just waiting for moments to be able to litigate and to legislate as well, and organizations like myself, Access Now, and I didn't mention the Telco Action Plan that we've developed, which is essentially the human rights, the Ruggie framework applied to the telco sector, which provides step-by-step guidance for companies and governments and how they should operate in these difficult and trying environments. Virgiana, over to you. I know you've been dying to say something, but we've just really got a minute each, if that's okay, or even less.
I'll do my best. Well, there are two things that I wanted to point out. The first one is about one of the last questions that you brought into the table. It's about who should be evaluating the companies, and maybe I have a different approach about it. I come from a developing country without a democratic country. So, well, we passed for some years of repressive regime, but we are now in a democratic country for like 20 years, so we have institutions. And in my country, telecom operators operates in a concentrated market. And civil society civil society organizes itself to pressure, but they're not strong enough. We are not strong enough. So the regulatory body has to play its role. there. And for us, it's important. We pressure the regulatory body to pressure the companies. So for us, this is an important actor. We are not afraid of them, despite that we know that they are much more closer to the companies than we are. But regulatory bodies with effective social participations and public consultations and public hearings and venues to meetings with consumers organizations and civil society organizations are what we want. And so this is how we deal with this question. And the other thing I wanted to say is about
just
transparency.
Quickly, if that's
yes.
okay, sorry.
It's about transparency. I really want to pose this note here. I think that transparency is fundamental, but regarding to human rights in telecommunication services, itself is not enough, because if the companies does things that don't agree with human rights standards, so it's not just enough that they be transparent about it. They should have another conduct about it. So this is important to make. We, in Brazil, we conduct a lot of researches about the terms of the conditions of service and the contracts, the company contracts, and we see there a lot of problematic things. And so it's not just being transparent, but accomplish and achieve human rights standards in the provision of the service.
Johan.
Thank you. Just a few final comments. We think that telcos are basically providers of communication, providers of, in that sense, freedom of expression, and that's important. However, difficulties arise, they will continue to arise, but we are happy to see that we've come this far. Companies should respect human rights. We welcome the industry dialogue, the GNI. We believe that together companies are stronger. From the government side, we do have responsibilities. We have responsibility to express our expectations on our own sort of performance, but also from the companies that we are involved with, and that is important. One thing which we haven't dealt with, and that will be my final point, I think it's extremely crucial also that we promote the free press and the free media, because that is extremely important to follow up and also hold companies accountable for what they're doing. So that will be my final comment.
Vivek.
Three very quick points. Who should do the reviewing? I recommend myself. I mean that only partly as a joke. I think David will speak to just how effective the GNI process was in terms of having independent third-party auditors make sure that companies were meeting their commitments and providing assurance to the public that they were. So that's very important. Second thing, I think one should not be too hard on telcos, because like every industrial sector, telcos have fallen into unanticipated consequences of their businesses and their technologies. We see this coming from a CSR perspective. We see this in sector after sector. So while proactive would be best, many cases you just have to be reactive. So that's the world we're in, and that's sort of the fallibility of human nature. Third point I want to make is building on Johan's point. Host country governments can play a major role in ameliorating human rights problems overseas. We really saw this during the Arab Spring, where the intervention of both the US State Department and the UK Foreign Office were instrumental in restoring the telecommunications network in Egypt. So let's not forget the home country responsibility here.
Thank you. Antoinetta.
Very briefly, my first point is we have to put in practice the Ruggie framework. Countries have the duty to protect human rights, and companies have the responsibility to respect them, as well as the remedy mechanism. And my second point is we need to promote and work for a true multi-stakeholder approach when dealing with these issues.
I just want to reflect back on your point about unintended consequences or unanticipated consequences. That is true to some extent, but I think we should not forget that there are many cases, in fact, where the company has entered into the environment in full knowledge that there's been decades of human rights abuses and that those technologies will be used de rigueur in the furtherance of those abuses.
No, I fully agree. That was just a sort of empirical point that companies generally don't realize that there's a problem until they themselves or someone, a peer company, feels it. That's sort of the history that I find in CSR.
Thanks. And Patrick from Telesonora.
Thank you, Brett. Very brief. First, many thanks for bringing us together, and I look forward to the joint mailing list to continue the discussion. As we've heard, the issues are complex, they are evolving, they are important because they are about individuals, they are about all individuals, and therefore also about societies. So they're not easy, and we need the help from national and international organizations, the UN, the EU, home governments, NGOs, etc., in order to be able to truly bring about change in protecting and respecting human rights.
Thank you. And I pass to Khadija last, and I do so for two reasons. One is because I think it's important that the user has the last word, and also because she's from the host country. Oh, hang on. Before I move to Khadija, there's somebody very important. David. Second last.
I'll be quick.
I apologize.
I just had a couple of points to make. One, actually, with regards to the Ruggie framework, which we've talked so much about and is so important, I think one thing to keep in mind that makes these set of issues unique is oftentimes when we think about the Ruggie Protect, Respect, and Remedy framework, we're thinking about a situation, and if you look at something like abuses with labor rights or something like that, where a company is not respecting human rights, and there's an obligation of the government in order to respond to that and deal with that. With this issue, what we're dealing with is governments that are violating human rights, but compelling companies to be involved in ways that then compromises them. And so that's a tricky issue, but it's also one that other industries have dealt with. Oil, gas, and mining has dealt with it through the voluntary principles for human rights, so that's another thing to look at. The second thing, and a key aspect of the Ruggie framework, is the concept of leverage. And when do you have leverage that you can use in order to help to mitigate human rights abuses or avoid them? And I think one of the advantages of a multi-stakeholder initiative like the GNI is that you can accumulate leverage and use it in different ways. And I think one of the reasons why we're looking forward to continuing to talk with the companies from the industry dialogue is we think that aggregating leverage across the entire ICT sector is one way where we can have maximum influence. And one final point just is an area that I think needs to be explored where influence can be had is also not just human rights standards, but technical standards. There's an alphabet soup of organizations, particularly I think the ETSI, the European Telecommunication Standard Institute, that develop the technical standards for things like how do you do lawful intercept. And we need to make those standards rights respecting standards, and that's one way we can, I think, have some influence.
I can't believe I left you out after those 3 points of wisdom. Khadija, over to you.
Well, after being bugged and filmed secretly in my bedroom, with participation of Azerbaijani state telephone company, I just live like my whole life is transparent, and I communicate very transparently with knowing that it can be read by everyone. I just would urge Ministry of National Security officials, those who are listening to our phone calls and looking at our emails, just to proceed it quickly so I wouldn't lose information in the middle. So that would be very important if the message will be delivered. I'm sure it will be delivered. And the second very important question is who is selling the equipment for surveillance to these regimes? And I think this needs an international investigation of this activity of companies who are giving all this remote surveillance and non-remote surveillance equipment to these regimes. And well, I want to finish with two quotes. One is very strong quote from my Belarusian colleague, Irina Khalip, who was interviewed by Swedish documentalists. The documentary was about phone tapping, and she just questioned would they build gas cameras in Hitler's Germany. So this is the same kind of responsibility they are taking. these companies, and it would be important to pay attention. And second is the Iranian Azerbaijani poet. He wrote just two lines that are very descriptive. Is you can't deny you said you love me. The guy who was tapping our phone is a witness. So this poem is just two lines, and the guy's name is Aydin Araz. He's writing great stuff from Iran.
Thank you. Thank you very much. Please join me in saying thank you to this fantastic panel, and I hope we've all learned something and can take this forward.